Hello, hello, hello. It's Attorney Mike Grevlin coming to you from Chicago, as usual. An old-fashioned intro. I haven't done it this way in a while. We got some really fun clips. It's the usual suspects. Big shout-out to Zach. Looks like he had a fun video over on his channel, Law Nerds Unite. And also Alyssa. They've been sending me good stuff all day. There's really some fun clips here. Let's do this thing, shall we?
Thank you very much. Today is the date and time set for an arraignment in this matter. Is there a consent to Zoom proceedings?
Yes, Judge.
Thank you very much. Mr. Harrington, can you see and hear the court still? Mr. Harrington? Mr. Harrington, the court can see the top of your head, so the court knows that you can hear the court. Mr. Harrington, are you there?
Could see your head.
Yes.
Thank you very much, Mr. Harrington. So at this time, how do you wish to proceed as to the arraignment in chief, Mr. Glazer?
I have a lawyer. I'm not agreeing any type of way to deal with anything right now. I have a paid for lawyer, and he's in Troy right now, so he can't be in two places at once. Maybe I need to talk to him, but I have a lawyer to represent me. So
That may well be.
Did he just say he's in Detroit right now? As in Detroit? I don't know.
Mr. Harrington, however, the correctional facility can only make you available at certain specific dates and times. Today is the date and time. So you may either use the gifted counsel of a seasoned and skilled attorney in the person of Mr. Glazer, or you can waive your right to counsel. Either way, you're being arraigned today, right now. So do you wish to make use of Mr. Glazer at this time, or do you wish to proceed on your own?
I proceed to deal with my lawyer that I paid
All right.
for.
Your lawyer is not here, nor have they filed an appearance with this court. So legally, you have no lawyer other than Mr. Glazer.
Legally, it must be a miscommunication, because that's probably what it is.
There is no miscommunication, sir. The Zoom number is published on the court's website. It is known to any practitioner within 5 counties that is familiar with the procedures, files, and records of this court. The court is going to proceed with arraignment. Do you wish to make use of Mr. Glazer, or do you waive your right to MIDC counsel?
I don't know what MIDC counsel means.
That means Mr. Glazer is operating under some very strict sanctions from the Supreme Court of the state of Michigan to look out for your rights as best as he can. He's desperately trying to do that right now. It is up to you whether or not you want that protection or you proceed on your own. But the court is not going to wait for a counsel that has not filed an appearance with this court. You may be confusing this case with another case you paid for a lawyer on. But this case is going forward forthwith. Do you wish Mr. Glazer's help or not? All right. At this time, the court is going to enter a plea of not guilty on Mr. Harrington's behalf. The court is going to note court appointing.
This is almost like the box fort, without the box fort.
Counsel, so IDSO will make a lawyer available to Mr. Harrington.
I'm just going to duck out of frame and pretend this isn't happening.
At his probable cause conference. And that probable cause conference will be scheduled within the next 10 to 14 days. If probable cause is either found or waived within 21 days, the matter will be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. Mr. Glazer, the court understands that as Mr. Harrington does not appear to be wishing to utilize your services, the court has to do its best to try to consider the issue of bond. The court does have before it a recommendation from the Pretrial Services Division of Oakland County Community Corrections. Mr. Harrington appears to have 12 prior convictions as an adult. He has not, or he has suggested he lives at the Electric Avenue address for quite some time. Let's see here. High school graduate, unemployed for 18 months. Reports the use of alcohol, cocaine, and marijuana. Prior criminal history, and release on recognizance is not recommended. At this time, the court is going to set bond in the amount of $11,000 cash, surety, or 10%. Additionally, these following conditions will apply to Mr. Harrington's potential release. He will appear as directed for all his future dates and abide any valid order or judgment entered in this case. You are not to leave the state of Michigan without permission of the court. Please don't commit any crimes on release status. Please do notify the court in writing of any change of address, telephone, or email. He will be making reports to pretrial services. No use of alcohol, marijuana, or any other controlled substance. Will participate in a substance and alcohol testing program. No possession or purchase of a firearm or other deadly weapon. Don't enter bars, clubs, liquor stores, or any business premises in Royal Oak or Berkeley, except for work, court, or medical reasons. There will be no release without a GPS tether. And there will be testing in the form of 1 ETG a week and 3 controlled substance tests per month. And again, the bond is $11,000 cash, surety, or 10%. That completes this arraignment. Good luck to you, Mr. Harrington. Mr. Glazer, I believe that's all you have.
It is, Judge. Have a great afternoon, sir.
You be well, sir. Well done.
Good. Who?
Okay, I have to thank Zach. He sent me this. I have not seen it, but Zach always sends me good stuff, and Regeer's on there. I just figure you can't lose. So let's watch it together.
Do I have first here in detention? Ma'am, what's your name?
Me?
Yeah.
Aspen Joseph is my name on my birth certificate. I would like to change it one day, but that is what it says.
Okay, Aspen Joseph.
Oh, we're starting strong. Aspen Joseph sounds like a kook.
So, Miss Joseph, this is Mr. Regeer. Do you have the case number on this one?
One moment, Your Honor. Based off my record, Your Honor, it appears to be 25 CR 081.
081. Okay. And so Miss Joseph is here today by Zoom, and all of these first appearances are going to be by Zoom today. Mr. Joe Regeer is here for the state. So, Miss Joseph, first of all, I want to make sure you understand what you are charged with. Do you have the charging document there in front of you?
No, I do not.
Was that a Joe Regeer? Maybe I heard it wrong, but I think she just said Joe Regeer, which is good because it's just so not fitting.
Okay, well, I'm going to go through that complaint with you so you will understand exactly what you're charged with.
Okay,
And then
thank you.
we'll talk about whether you need an attorney and bail, okay?
Okay, thank you. And honestly, I wouldn't want to do bail if it costs my family any money. I'd rather do time because then I know that my family can save their money. I definitely don't want to be a burden on my family for sure.
All right, well, we'll get to that issue pretty quick. Okay, so it looks like
Odd, but I guess sort of sweet. I don't know where we're going here.
there are 4 counts on this complaint, and all of them were alleged to have occurred on February 21st of 2025. So count 1 alleges that you did without authority enter into or remain in a dwelling that was a house at 9920 Northwest 10th Street in Towanda, Kansas, in which there was a person, Calvin Varner or Jared Greenwood, with the intent to commit a felony, theft, or sexually motivated crime therein. This is a violation of KSA 215807B1 C2A. It's called aggravated burglary. It's a level 4 person felony. Count 2, that you did unlawfully and knowingly by means of fire explosive damage property, which is not a dwelling. In this case, it was clothing in which another person had an interest without consent of that person, and this was a Tara Varner. This is a violation of 2158-12A1A. It's called
You said I
arson.
burned someone's clothes on fire?
Yeah, now just listen.
Okay.
I'm not asking you if you did it. I'm
Okay.
just
Okay, it's official. She's probably fun.
telling you what you're charged with, okay?
Okay, thank you.
This is called arson, a level 7 non-person felony. Count 3, that you did unlawfully damage, deface, or substantially impair the use of property, in this case, a toilet, the floor, the wall, and a window, with intent to injure or defraud an insurer or lien holder, in this case it was Calvin Varner, damage being a total value of at least $1,000 but less than $25,000. This is a violation of 2158-13A2B2. It's called criminal damage to property, and in this case it is a level 9 non-person felony crime. And count 4, that you did unlawfully obtain or exert unauthorized control over property or services, and in this case it was clothes and U.S. currency, with the intent to permanently deprive the owner, a Tara Varner, of the possession, use, or benefit of the property or services valued at less than $1,500. Violation KSA 2158.
What the hell is going on here? Do we have a clothes theft via arson? This is some crazy out there stuff. That's okay. Joe Regier is going to straighten it all out for us.
801A1B4. This is called theft. It's a Class B non-person misdemeanor crime. Now, do you understand what you're charged with in all 4 counts?
I do understand, and
Okay, and I'm not asking you if you agree, just if you understand what you're charged with.
yes.
All right, okay. Now, just for your information, you've got 3 felonies and 1 misdemeanor. The misdemeanor, if you're
2
convicted
felonies and 1 misdemeanor.
3 felonies, 1 misdemeanor.
3 felonies, 1 misdemeanor?
Yes.
That is crazy.
3 felonies, 1 misdemeanor. The misdemeanor crime is a Class A. If you're convicted of that, the maximum penalty is 1 year in jail. But on the felonies, a level 4 felony, level 4 carries.
You know, that's not crazy. What is crazy is that you're trying to steal something and setting people on fire. That's what's crazy here, my friend.
Depending on where you fall in the sentencing range, anywhere from a minimum of 38 months up to a maximum of 172 months in prison.
How many years is that max?
She did go full emoji there, didn't she?
172 months. Okay, now on level 2, which is a level 7, and count 2, which is a level 7 non-person.
That's like a lot of years, right?
Mm-hmm.
That's like 15 years.
The minimum on that one is 11 months in prison, and the maximum is 34. And on count 3, which is a level 9 non-person.
Thank you, KDM.
Level 9. That has a minimum of 5 months in prison, the maximum up to 17 months. And that all depends on where you fall on this sentencing grid.
Okay, let's do the process.
Let's talk a little bit about attorneys. Are you going to hire an attorney?
My dad, he has an attorney that he goes through, and I'd like to use his attorney.
Okay. Have you had a chance to talk with this person yet?
No, because I'm just now detoxing from being roofied, so.
Okay. Well, most certainly get in touch with that attorney just as soon as you can. If you can't afford an attorney and you need one.
I haven't been able to make a phone call either.
Okay. If you can't afford an attorney and you would like, you can apply for court-appointed counsel. If you qualify for court-appointed counsel, I'll appoint an attorney to represent you. You may be required to repay some or all of the cost of that representation, but that's something that's determined at a hearing at a later date. So keep that in mind as you go forward. Now, Mr. Regier, what is the state's request with regard to bail bond in this case?
Your Honor, besides all standard conditions with special emphasis on no contact with the victim or the property, as well as SCRAM monitoring based off of the defendant's statements on the record today, the state is recommending 7,500 cash or surety. This is a case where, pursuant to page 2 of the affidavit, there appears to be an allegation of damage to multiple windows and items scattered in front of the garage of the attached to the residence, as well as burnt items in front of the garage, as well as law enforcement find the residence ransacked in disarray, as well as damage done to a toilet, causing flooding and damage to multiple levels and areas within the home. It would also appear that the defendant is alleged to have been found by law enforcement lying on the floor inside the residence and making comments of burning down the house and starting over, as well as suggesting that it was
Like my brain, since I was drugged, I was thinking of Carrie Underwood, the song where she's like, just burn down the house and
Ma'am,
start
ma'am.
over.
Honey, don't make statements on the record, okay?
Oh.
Because your attorney,
Judge busts out a honey. Honey, stop.
when you get an attorney, he'll discuss with you how to proceed. And I'm sure he or she wouldn't want you making statements on the record.
Yeah.
Okay.
No, I'm pretty sure that's okay because I did feel like I got roofied and I'm just telling the truth. So honestly, if my
Okay.
attorney doesn't want
She might have a good defense, but she needs to shut up. She needs to shut up and discuss that with her attorney. It is not getting her out today.
me to be truthful, why would I want to be a part of any system that is about lying? Is this
Okay.
true? Is our system about lying or telling the truth?
Okay. Ma'am, just speak only when I ask you a question, okay?
Okay.
Okay, go ahead, Mr. Regier.
To continue, Your Honor, there are allegations that the defendant was located, suggesting that it was the end of the world, as well as admitting to burning plastic at the residence and damaging windows. Therefore, based off of the particular facts of this case, the state does respectfully submit that 7,500 cash or surety, subject to all conditions, iterated on the record, is highly appropriate.
Okay. Do you have any information about her criminal history, about her residence, that type of thing?
One moment, Your Honor. Your Honor, based off of my notes, it would appear that this is a defendant with little to no prior conviction history. However, this also appears to be a defendant with no fixed abode of residence, if any. Therefore, the state does consider her a significant flight risk.
Okay. Okay, now, Ms. Joseph, I'm going to ask you a couple of questions. Where do you reside?
Well, right now I'm currently getting my address changed. So I moved in with my mom and her boyfriend because it was kind of a decision. Should I move with my mom and my boyfriend, my cousin and her husband, or
Okay.
my
What city? What city is that?
Wichita, Kansas? All the places are in Wichita, Kansas. So during this phase, I had 4 different places I could have stayed with, but I needed to get a P.O. box because I was like, okay, I'm not really sure where I'm going to
Okay,
go.
really all I want to know is the city. Have you lived in the Wichita area your whole life, or is this something new?
My whole entire life, I've lived in Wichita in the same areas. So
Okay, okay. And the state's asking for 7,500 in cash or surety. Do you think that's too high, too low? How do you feel about that bond?
$7,000.
7,500. You would contact a bondsman and pay a portion of that.
It is pretty high, I would feel like, because technically I've been saving up and working every day of my life, and I just spent all my money on the car that I just drove for the first time that I just wrecked, and I was stranded in the middle of the nowhere, and that's why I had to go to that house anyways.
Okay, so if I put your bond at, say, 5,000 cash or surety, do you think you might be able to make that, or contact some family members?
How much time is it? Because if it's just staying in a room and no one's gonna hurt me, as long as you guys promise not to hurt me and I can trust to live with you guys, I will live with you guys. But my mom also told me that they charged her $2,000 for one time when she was in jail. So I just don't. I'd rather
Well,
go out.
I don't know what kind of a deal you might make with a bondsman, but
Okay.
for right now, I'm going to set your bond at 5,000 cash or surety. Obviously, if you make bond, you're to have, I'm ordering that you have no contact with the victims. In this case, the listed victims, don't go back to that property.
Okay.
Don't make phone calls to them. Try to contact them through any type of media, social media, or anything. And I think a scram is probably a good idea for you, considering some of the history you've told today. So I'll order that as well.
What is the scram?
It's a unit that monitors alcohol and
I don't drink alcohol at all.
Mr. Regier,
I've never drank
What-
alcohol. I'm
oh.
anti-alcohol, and I think it should be banned. Actually, I'm
okay.
pro-banning
Okay.
alcohol.
Thank you for that information, Mr. Regier. What else does the scram do besides drugs and alcohol?
Okay, okay, maybe drugs, but alcohol, that one's lame, bro.
Okay. Okay.
That's just me, though.
Okay. I do drugs, but I don't drink.
Your Honor, that is the state's primary purpose of a scram monitoring device. If the court has certain concerns about that, the state may respectfully amend its earlier recommendation to include GPS monitoring. If the court has certain concerns under the circumstances.
No, that's fine. Let's go with the scram, no contact. Obviously, no other violations of the
I
law
would be
while you're.
GPS tracked because I don't mind all my family.
No, I didn't, ma'am. I didn't order GPS on this.
Okay.
I ordered the scram, 5,000 cash or surety, no contact with victims or the property, no other crimes committed during the time you're out on bond. Most certainly stay in contact with your attorney, whoever that is. The next setting on this, Miss Amy, will be.
It'll be before Judge Hart on April 21st at 2:30 by Zoom.
Okay, April 21st, 2:30. It will be by Zoom. And Miss Joseph, if you decide that you're not going to hire the attorney that you made reference to, then you can always fill out the form requesting court-appointed counsel, and we'll take a look at that, okay? Okay, let's go on to the next case.
Although she's got felony charges, so she wouldn't get Durham Patterson.
And Judge, I will say that Mr. Stangy, I'm not sure how to pronounce his last name. I think he is here on that 25 CR5. Brady McLaren.
Okay. Yes, Mr. Stang, let's take up your case.
I also I've got no problem staying in jail if they don't hurt me. I don't know what you've heard about jail, but that's the sort of thing that happens there. Also, the motherly advice. My mom said, gave me advice on going to jail from, when she was in jail. That's nice. Family, is incarcerated together, stays together.
Ms. Flanagan and Ms. Adams. Doesn't matter.
Oh, buckle up for this, people. Buckle up for this. We have got some geriatric Karens, and it's about to get real.
Either one. And if you'll both stay standing for me, please. Raise your right hands. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes.
All right, two of you reside in the same building, is that right?
Yes, Lotus Court Apartments, Patterson Street, Olympia.
Okay. So, Ms. Flanagan, you indicate that Ms. Adams makes a habit of calling you names. She takes your walker and she pushes it away from you. She does something with her cigarette butts.
I mean, this is terrible. I'm sorry, but it's funny. Yes, it said, yes, I get it. But takes her walker and hits her with cigarettes? Come on. That's funny. I'm sorry.
In the eye.
All right. Anything else?
Well, I do have something here from a friend of mine. I've been there 4 months and I have acquired some friendships there. One is Eileen L. Pierce. She's a very good friend of mine. She actually wrote something, an affidavit, to have me read to you.
Go ahead.
She said, I was doing my laundry, I believe it was on February 18, 2025. I left one load in the dryer. I had company over. Went down to get my laundry out of the dryer, but someone took my laundry out of the dryer, put their laundry in there. Was still 22 minutes left on my dryer. There were 6 other dryers open to use, so there was no reason for anyone to mess with my belongings. I went out into the lobby to see if anyone was been doing the laundry room. Martha and Jimmy, her friend in the lobby who sit down and read books. I asked if they had seen who went there, and they said Julia Adams. She just came out of the laundry room. I went back up to my apartment, and the time was then 6:30 p.m. I started to fold my laundry and found there was white dog hair all over my laundry and snot all over my black hand towels. The dog hair was short, white dog hair, which was her when she walks. About a half an hour later, I went to take my dog, Bella Rose, a Cocker Spaniel, out of the potty and went out front door, turned left to go back and get the dog poop bag. I got about halfway there back to where the bags were there and Julia was there with the white chihuahua. I turned around to go back and there was an aggressive pit bull on the other end of the walkway. Bella and I were stuck in 2 dogs, aggressive. And Julia said to me, you have to be fucking smarter, excuse me, Your Honor. You have to be bleeping smarter than the bleeping dog. I don't know why Julia is talking to me in this manner, because I've never had any problems with her. The only thing is that I talked to Martha Marie Flanagan, and Julia doesn't apparently like that. But what is going on between Julia and Martha Marie has nothing to do with me. I wrote this because I won't deal with someone who's obviously escalating at the Lotus Court Apartments and bullying me, Eileen L. Pierce.
All right. Ms. Adams?
Never happened. If it did, it would be on camera. There's cameras in the laundry room.
Okay. Talk to me about the concerns that Ms. Flanagan's indicated. Do you mess with her?
No,
Not at all.
no. I have paperwork here if you'd like to look at it.
What's the paperwork say?
That I don't mess with her and she messes with everyone else. These are written statements from these people and the people. There's tenants, the other ones that they're willing to come in and testify, and there's also going to be, there's 4 people filing a restraining order against her tomorrow. So would you like to see these?
No, not if they're present, I don't.
No, these people aren't present.
Okay, well, yeah, no, hold on to those. So why don't you bring one person up at a time. Just come on up, have a seat next to Ms. Adams.
My name is Cheryl.
Yeah, Ms. Lipsinger, come on up and just have a seat right here.
Sorry, we call her Sissy, so.
That's okay. And Ms. Lipsinger, raise your right hand for me, please. You swear the testimony in this case will be the truth, all truth, and nothing but the truth.
Yes.
Okay, go
yes,
ahead and have a
sir.
seat.
Thank you.
Yeah.
Sir.
Thanks, sir.
Okay, and what do you know about the relationship between Ms. Adams and Ms. Flanagan?
So, I know that Miss Martha doesn't like Miss Julia from the very beginning. And I know that recently there was a restraining order served on Julia.
No contact.
Oh, no contact, whatever. And so now everyone that is with her or around her has become a target of Martha.
And I actually have never had problems with her. She pretty much ever leaves me alone, stays away from me. But since me and Julia have been friends, now she picks on me because me and Julia are friends and she doesn't like Julia. So she waits for Julia in the laundry room and Julia goes out to smoke. So when me and Julia were going out together to smoke in a way to go smoke, we have to go out down a hallway past the laundry room. So when we walk past the laundry room, Miss Martha comes out behind us and she walks so good. You walk really
Okay,
good.
no, just talk to me.
She walks really good without her walker.
Mhm.
But at the apartment, she walks with a walker like this. And
I didn't notice that before she lost focus, and then she starts talking to her. The judge has to redirect her. This is so good.
she comes out of the laundry room with her walker really fast. You're in violation. You're in violation. I'm calling 911. And she starts trying to ram me and Miss Julia with her walker. And then she came behind us and tried to get out the door before us and then calling 911. And she said, that's on camera, that's on camera. And she does that to everybody.
Okay, thank you very much. You can go ahead and have a seat back there.
Okay.
And did you have somebody else who wanted
Miss Tony.
She's witnessed her behavior, Shirley.
to? Okay, if either one of you want to come.
I didn't know it.
Okay, and raise your right hand. You swear
And don't call me Shirley.
the testimony in this case will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
And your name is?
Tony Barlow. Tony, T-O-N-I, Barlow, B-A-R-L-O.
Oh, Barlow. Okay, thank you. Go ahead and have a seat, Mr.
Okay.
Barlow.
Thank you. So I'm Cheryl Litzinger's caretaker. And so I guess my reason to be here is on behalf of both of them, but mostly Miss Litzinger, because
The names are perfect, straight from Central Casting.
her stress level and her ability to leave her apartment and just kind of be natural, be on, a regular day with her has subsided. It's down to a minimal now. So, because before, she was being, very social and being able to be out, but this has really caused undue stress on a lot of people. And I can't talk for them, obviously, but I can talk for Miss Litzinger. And there has been a change in her temperament and how she wants to leave her apartment now. She's afraid that she's going to end up getting something against her just by meeting her in the hallway.
Okay.
It's, it's just been that
So
kind of
have
thing.
you seen any of this?
I have seen her behavior. Yes, sir.
Describe it.
I've
What you have seen.
I've seen her try to hit somebody with an umbrella.
By her, you mean.
Oh, I'm
Miss
sorry, Miss
Flanagan?
Martha. Yeah.
Okay.
Yes.
Okay, go ahead.
She's been verbally offensive to people, and I came up right after she had spat in someone's face. And actually the police were there at the time.
That never happened.
Yeah, hold on. I'll get
That
back
never
to you.
happened.
Ms. Flanagan, I'll get back to
All
you.
right, that never happened.
I'll
Okay.
let Ms. Barlow.
Judge, it's Martha's reign of terror. It's that simple.
So,
That is a lie.
Go ahead.
okay. So, there's been many, many incidents. She called 911 on this fella. He actually is dead now. He's He had lung cancer, and it was this issue with the elevator, and her not letting him out of the elevator, and he did like push her with his walker. So anyway, there was a big deal. She's, in my opinion, she's been a troublemaker from the word go, and she has all these protective orders on so many different people, and it's
That is
just
not
a
true.
nightmare.
I don't have any.
Okay, Ms. Flanagan, don't interrupt, please. Go ahead, Ms. Flanagan.
That's it. That's all I see. And I'm my main concern is Miss Litzinger, and her ability just to leave her apartment without feeling like she's going to be either assaulted or have a protection order placed against her.
Okay, thank you very much. And ma'am in the back, did you wish to say something?
This is Shirley.
Okay, thank you. Shirley, if you'd raise your right hand for me. Swear that testimony in this case be the truth, the whole truth, and nothing but the truth. Okay, and your last name is?
Peniagua.
Peniagua. Okay, Ms. Peniagua, go ahead.
Okay, I've been pretty much neutral with, I try not to get involved with anybody's stuff, but I have seen Martha come unglued on a lot of people. And they try to, we're all kind of out smoking. She comes out and refuses to leave in the area we're at. So the whole group has to get up and walk to the front of the building. So we have time to visit. And we watched her try to poke somebody, this Ellen that she's got a state from. She tried to poke her.
Have you ever seen
management tried to get in or had to get involved?
Have you ever seen a situation in which Ms. Adams has initiated something negative with Ms. Flanagan?
I never witnessed it. I was at church one day and I heard about it when I came back, so I wasn't involved.
All right. Thank you very much, Ms. Peniagua.
You're on the
Right, okay, Ms. Litzinger, hold on just a second. Okay, thank you.
Thank you. Just say one more thing.
Sure.
Oh, Your Honor, Miss Martha's told everybody that Miss Julia is an alcoholic, and that's not true. Me and Miss Julia have been friends for a really long time. She's not an alcoholic.
Okay, thank you.
Thank you.
Ms. Adams, do you have anything more you would like to say?
Yes, I came up early and I was writing a statement out for a friend of mine who has litigation against her. They're in court the same time we are. So that's another witness of mine that's not able to be here. But that's who's gotten the brunt of her abuse, along with myself and many other tenants. But she's escalating. I thought it would get better. I thought Lotus Management would handle it. Nobody seems to be. So I'm after me being protected from her, all the other tenants, and most importantly, Barbara, who again is in another courtroom going against her because she was verbally assaulted and physically assaulted from her. They did mention the other gal, she's spit in her eye, so she's got to, I'm going to take her to the police officers to have her, she'll file assault charges. She needs to go to her doctor to be tested for anything that may have been transmitted. She's doing a restraining order. I'm doing a restraining order, and I believe 3 other people. And then many people, if you'd like their number, name, anything from them, if you have any questions, even the staff at Lotus. But I have these written ones that I wasn't able to submit to you before this hearing.
So you all live in one building?
Correct.
And Are you down the hall from each other?
No, I'm on the 5th floor and she's on the 2nd floor, and she also came up last night to my floor,
Mhm.
which she's not supposed to. And then when I go out to have a cigarette, she runs up to me and says, "You can't be out here. You have to go away now." She doesn't understand the no contact order, which is fine. You know, I don't know that she's capable of it. So
Tell them that now.
Your Honor, may I speak?
Oh, okay, I'll get back to you. So,
a lot of people couldn't make it here today for other obligations they had, but wrote to you.
and how long have you all lived in the same building?
I went in on September 27th. Anybody else's date, I do not know.
And was Miss
We've been-
Flanagan already residing there?
Pardon me?
Was Miss Flanagan already residing there?
I couldn't tell you that. I have no idea.
When did you come to know Miss Flanagan?
I can't remember that either because it's just been a nightmare since. So I'm, our staff could tell you that. Who were in charge of moving everyone in. I don't even know when these people moved in. I know they're my friends now, but can't even remember their
That's okay.
floor number.
All right, Miss Flanagan, go ahead.
Yeah, here's another one from Kathy. Last night when I was on her, I didn't even know where she lived until a week ago when Shirley served because she saved me $75. So this is from Kathy. The girl that talked about her using profane and foul language. None of what she said is true at all. We have 9 incident reports, 5 grievances, and the management is aware of her.
This coming from a woman who dropped the F-bomb twice while reading a prepared statement.
She's the one that
In
assaulted her
court.
the other day with the Colombian lady, and we do have it on video. The video was when Josh Dannenberg, the property manager, actually saw her do it. She called me demon. She's been on the elevator. Dave just got out of the hospital. He could come, but this is a letter handwritten from Kathy, my friend since I met 4 months ago. I did not arrive till October 29th, so I didn't even know she was living there. Anyway, apartment 311, I, Kathy 30, have known Martha Marie for 6 months. She is a nice person who doesn't hurt anybody. Witnessed by Nathan, my son, on February 11, 2025 at 9 p.m. Lotus Court. Incident report, February 21, 2025. Your name, Martha Flanagan, Lotus Court. Person involved, Julia Adams. Apartment, we just found out, I didn't know she lived on the 5th floor till a week ago. A lady named, I came back from church as I'm becoming a master and a minister, and I was gone for 3 hours. And so what she said is
Oh, yes, this is Alyssa's fault.
the absolute fabrication of the entire statement. Julia Adams was simply with my walker. She's the one that blocks it. In other words, she's screaming and screaming and screaming and putting her fist and slamming down her fist. And she's, as far as the other lady in apartment 501, Kim, was the one 3 months ago that said that she wrote the management, not me, about her alcoholism. I didn't know anything about her. I only know from Shirley that her boyfriend beat the living crap out of her a year ago. Her violence is excessive. She's accelerating her behavior. She came to my floor on the 2nd floor.
I don't know anything about her, but I got this nugget with some DV. I think I'll throw out here.
Until she was told by management, you cannot go within her. And then Shirley was nice enough to save me $45 from calling in the police. We did call 911 yesterday, and they're awaiting a decision, Your Honor. So what she said is absolutely fabrication, completely.
All right, thank you.
I do have a video of it all as well.
Sir, can I be excused?
Yes, of course.
Yeah.
Take care. Thank you, dear. Have a good day. Be well.
And Ms. Flanagan, has the order that I entered previously, has that changed anything?
No, Your Honor. Just accelerated, got worse.
Oh, yeah. This has been going on a while.
Which is kind of what I had assumed listening to everybody here.
Pardon?
Which is kind of what I had assumed listening to everybody here.
I'm lost as to what you're assuming.
I'll tell you in a moment.
Oh, I'm sorry. Okay.
That's okay.
Are you willing to?
How many people live in this facility? Any idea?
60.
I believe there's
60.
64 rooms.
Okay, thank you.
And Sam passed away. He had lung cancer for 5 years.
That's the man she
Yeah.
tried to.
And that's that's the scooter that he put
That's
through,
enough.
So
That's enough.
she's also
That's
doesn't know
enough.
the whole story. When Enrique gets
That's enough. That's enough.
Thank
Talk
you.
to me. Ms. Flanagan.
Sir,
Okay, so you have 60 of you that live in this building, give or take.
yes, Your Honor.
And I have some people saying that Ms. Adams is the problem. I have some people saying that Ms. Flanagan's the problem. I'm hearing that some people are going to seek orders against Ms. Flanagan. I don't know if there are other people seeking orders against Ms. Adams.
No.
But,
Yes.
oh, hold on.
No.
Okay.
Let the judge
I-
speak, Julia.
I'm glad I don't live here. That's all I'm going to say right now. You guys would be mean to me. Protection orders aren't going to change anything down there. That's really why I asked Ms. Flanagan the question. The fact that there is a temporary protection order hasn't changed a thing. I don't think the police have any desire to come into the building and lock up all 60 of you because you can't be nice to each other.
No, they said they come-
I don't think that's going to happen.
Well, they
If
said
I
they,
issue the order, that's really what you're asking me to do.
that's correct. They said they would if you do the order, Your Honor. That's what they said.
Well, they're not going to lock up all 60 of you.
No, we're
because
just
you're-
talking about
Okay,
Julia.
Ms. Flanagan,
Okay.
you're all, no.
I know, but she lied
can
through her
control
teeth.
it.
She
Nobody
lied
needs
through
to
her
shoot.
teeth and they falsified the statement.
Okay. All right,
And
Ms.
that's a
Flanagan.
fact.
Okay. But you all are saying the same thing about the other
Mhm.
one. So I'm pretty confident that this is just a paper exercise if I were to issue it. I'm going to not issue it. Frankly, this is going to fall on the management. They're the ones who work there, live there. They're going to have to keep an eye out and make their own determination. I'm not in a position because you each are presenting other people saying, no, if it's her fault, it's her fault. And police don't want me to issue an order because they don't want to have to start coming arresting all the people in the building. And there's not enough room in the Olympia City Jail for all 60 of you, and the accommodations are not nearly as comfortable as the ones you have in your building. So I would just ask that you have some degree of respect for the others and just give each other a little grace and as much room as you can so that you aren't bumping into each other and you can find a little peace in your lives. All right. I have signed the denial order. Ms. Adams and Ms. Flanagan can remain where you are. We'll give you a copy of that order. And were I to hear other cases about this, unless there's something very different, the cases would all end up pretty much like this one is. So I'm just letting you know.
All right, Your Honor. Thank you.
Yeah.
Thank you for speaking and teaching us. Thank you very much. I appreciate it. I listened. I heard you.
Are you interested in the paperwork?
No, I don't need it. Okay. So, Ms. Flanagan, Ms. Adams, just wait and we'll give you each a copy of what I
Thanks, sir. Oh, I'm sorry.
And Ms. Adams, here you go.
Thank you.
Welcome.
Yeah.
And Ms.
Is it possible to talk to you after she leaves?
No, we can't do that.
Your Honor, she's trying to manipulate as she
Okay.
does everyone.
All right.
She's miserable and she is.
Okay, that's enough. I told her she couldn't say anything to me, and I'll tell you the same.
She's trying to manipulate.
All right.
Thank you.
Yep.
I'm not going to tolerate her doing it.
Lewis County, Your Honor, they would have granted it, and they do arrest you if she does have to pay. It's serious. If you don't have a clue, we're gonna come back here. We're worried she has a firearm, so I want to talk to management. Thank you. I thank you. You're one of the rare judges left. Thank you, Don.
No. Let's let that linger for a moment.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Warren William Camplan III. It's case number 2024 CR 316. James Watts appears as defense counsel. Mr. Camplan appears from a court security maintained Zoom location at the Butler County Judicial Center. Amber Norris appears for the state of Kansas. This matter comes before the court at this time for pretrial conference. What announcement is made at this time, Mr. Watts?
Your Honor, after discussion with my client, the state had made in this case a more than fair offer in this matter to resolve this by a misdemeanor with significant restitution. My client does not believe at this time he could accept that offer. He would ask to continue this case. Well, Mr. Camplan, did I misstate your position?
Mr. Camplan?
All right. The fact that I don't want to do the thing is only because I don't want to go to jail today.
Well, Judge, as I told you,
That's all I had to say.
if the offer is accepted, I don't believe the state's going to be asked for you to be in custody today. But as I mentioned, the court has the authority to act in its own regard.
I know. That's what I'm afraid of.
Well, Mr. Watts, is the issue of restitution settled between you and the state?
Judge, the state has asked for a restitution figure of what would be $23,275. My understanding is my client is willing to accept that figure. He obviously does not have that funds. He would have to be on a payment schedule to make that payment. His concern is in large part whether or not he would be placed in custody today. As I explained to my client, I don't believe that's likely to happen, but the court has the legal authority to do so.
All right, I'm just curious. What is there a plan for restitution payment here? I understand the aggregate amount that's been apparently agreed on, but is there a plan for repayment?
Your Honor, my client is on a Social Security payment of a little over $800 a month, between $800 and $900 a month. I don't remember the exact figure. He is hoping to get some assistance through the VA that might be able to supplement that somewhat. But that is at this point his sole source of income. So he's going to have to be making monthly payments. And I suggested probably $100 a month. That will be difficult for him because he is effectively homeless at this point. As Your Honor well knows, because Your Honor did the preliminary hearing in this case, there was a bank account that has now been frozen by the court. My client no longer has access to. At this point, I don't know how much money is left in that account. I don't have access to it either. Presumably, whatever funds in that bank account still exist would be surrendered to the state in payment of that restitution. The state had originally offered a restitution figure of $45,000, I believe $550 if I remember correctly. Yes, $46,550, excuse me. $46,550. I noted to Ms. Norris that realistically my client has no realistic way to pay that figure back, even on a monthly payment schedule. Her response was that perhaps half of that number could be agreed to my client, which would come to $23,275. He does not have $23,275 in cash or available assets to pay it immediately. He would have to be making irregular payments, and he has a limited income to do that. I presume that the remainder, the other half of roughly $100,000 medical bill, which is the issue in this case, is the other $54,000, give or take, is remaining in that account. I don't know because I don't have access to that account, but I presume that that figure is roughly what is remaining in the account. if that makes any sense.
Not entirely. Who else has access to this account at this point, Mr. Watts?
Your Honor, I don't believe anyone else has access to this account. Ms. Morton is in a treatment facility. Although she has legally access to that account, she has no actual way to access it, as far as I know. I know that Mr. Camplan was barred from access to this account by this court in October of last year. I don't know of anyone else that has access to that account.
Your Honor, I haven't gotten an update from DCF about who has access to the account, but it is Miss Morton's account. It is not the defendant's account. And it was basically the bulk of the money in the account was from the proceeds of the sale of her house. So the account is for, you know, basically is Miss Morton's, the victims. So the restitution would not be coming out of that account necessarily. That's money that's utilized for her care and whatnot. I suspect that they've accomplished a guardianship conservatorship because that's what they were working on through DCF, and that whoever that is has access to that account and interest at this time. But I have not gotten an update from DCF about, you know, who that is.
I just hate that these funds might be frozen when there is an owner of that account that needs the benefit of those funds.
Your Honor, you have not allowed this defendant to have access to the account, and Entrust froze it temporarily until the defendant couldn't have access to it anymore. And as far as I know, it's not. Miss Morton would have access to those funds, although she is not in a position to do that on her own.
All right. Again, my concern is that there's no one exercising control over those funds for Ms. Morton's benefit.
It's my understanding that
said about DCF, you're asking me to trust that DCF took care of something, and sometimes I have difficulty with that.
And all I know is that they had started the process several months ago for guardianship conservatorship, and I mean that was probably maybe July or October. I mean it's been quite a while ago that I was told that they started the process. But like I said, the bank only froze it predominantly because they didn't want the defendant having additional access, because he kept taking money out in large chunks, like $10,000 at a time.
All right. Condition on this court being able to take a successful plea from this defendant. What new charge is the state contemplating here?
Your Honor, it would be misdemeanor mistreatment of a dependent adult under 215417 A2 B B2 F, which would make it an A person misdemeanor, and it's under the basically it's the misdemeanor version of the alternative, which is basically a violation of a power of attorney.
All right. What plea is it contemplated, at least, Mr. Watts, that your client would be entering?
Well, Your Honor, if my understanding was correct, my client was seeking to continue this case. Mr. Camplan, do you now intend to enter a plea under that, either a guilty or a no contest plea? What do you want to do?
I cannot go to jail today. There's just too much happening and too many things would suffer in the process.
Well, sir, as I told you when we met privately,
And it doesn't have anything to do with money.
Sir, I don't think that's likely to happen, but as I mentioned when we spoke privately, the court has the legal authority to do so. I don't know that the court's going to do so, but has the legal authority to do so, and I cannot guarantee you what the court will do.
I understand. That's why I'm worried.
I'd put him in jail.
So how do you wish to proceed?
Oh, Melissa can say yes and no and make decisions.
Okay, sir, that's not the question I asked you.
I know it's not. I just wanted to say that.
How do you wish to proceed today? You can
Jury
accept the
trial.
misdemeanor, or you
Jury-
can set the,
Jury trial, I need time. The witnesses I need are no longer staff at hospitals, and I'm having trouble locating them. One of them might even be out of state. I don't know yet.
and Your Honor,
All right, Mr. Watts, if this will help bring some closure to this discussion. This court, if it accepted a plea even to a misdemeanor today, I'm going to defer sentencing. This court wants to know exactly what the status of these funds are that Mr. Camplan previously had access to at Intrust Bank. I prevented him from getting in there. I want firm information, verified information, which I presume the county attorney's office can provide this court with a little time, as to exactly what's happening with those funds, how much is in there, and what this court needs to do, if anything, to facilitate these getting to the benefit of the victim in this case. So I will be deferring sentencing. Now, I don't know if that helps this discussion or hurts it.
that
What
means,
does that?
that means, sir, that the state is not going to do sentencing today. You would not be taken into custody today.
It also makes me suspect that when he sees how ugly this is, you're going to jail.
Mr. Camplan, what do you want to do here?
Jury trial, Your Honor.
Your Honor, if my client wants to have a jury trial, he believes that there are witnesses that would support his theory of defense. I have encouraged him to let me know who those witnesses are. And as I told Mr. Camplan, I must know who they are, how I can reach them in order to subpoena them, and what it is they're expected to testify to in order for me to consider subpoenaing them as a witness. Mr. Camplan has some difficulty doing that because he's having difficulty finding the witnesses he believes he needs. I would ask on his behalf to set this matter over so he can obtain and find and identify those witnesses.
All right, I understand the nature of the request. I guess I want to make sure I understand the defendant's position here. The state has made a misdemeanor plea offer to you with a 50% reduction from their perspective in the restitution that you'd be ordered to pay. This court, if the court were to accept the plea today, I've already related that I'll be deferring sentencing to a later date because I need more information regarding the funds in this account. So you're turning that offer down?
Explain that to me, Your Honor. I didn't.
I thought I just did.
You did, but I was listening to what you said before, and the part. Could you please repeat it?
All right. The state is offering that they would, upon successful plea, amend the charge in this case downward from a felony, a presumptive prison felony, to a Class A misdemeanor. Class A misdemeanors in Kansas are punishable by up to a $2,500 fine and up to 1 year in the county jail or both. The state has also, as part of this plea agreement, apparently agreed to discount the restitution amount from $46,550 to half that figure, $23,275. And at sentencing, this court would have to work out with you some understanding regarding a payment plan on this restitution. By accepting their plea, it resolves the case. There wouldn't be a jury trial, but there would be a sentencing date where the state would return with more information that this court is desiring, and then you would be sentenced at a later time.
I understand that, Your Honor. But no one understands my position.
All right.
Laws
What is that exactly?
Laws have been broken. Laws have been broken, and I'm not allowed to talk about it.
Okay. I'm really just focused on what laws you might have
I
broken.
understand. I know.
Yeah.
That's what I just was trying to say. I'm sorry, Your Honor. Go ahead.
No, you go ahead.
That was a great response. Yes, laws are broken every day, all the time, all over the place. What we're here to talk about right now is the laws that you broke.
I just want to make sure what your position is today.
Your Honor, this jail thing has me worried. And I have a polytrauma appointment in June. I just had one 2 weeks ago, and I have another one in June. And I have a polytrauma, and then a podiatry appointment next month, which they just rescheduled for. They want to do surgery.
No one cares.
But they can't put me under. I have to be awake. And I'm trying to decide whether or not I want to be awake for that. I don't know if you understand. I'm sure you do. But anyway, I have a letter that was written in 2017 from a doctor that the animals are support for me. I can't live with the fact that if I'm put in jail or something, that no one will be there for them. I have other things in storage that I'm trying to work on because the storage unit that I had was bought out by another group of people, and the payments for the storage I was making were canceled because they had a different bank account, and I got behind. And I'm trying to work with that also. That's not just Melissa's things, but also mine. A treatment center that Melissa was going to go to in 2020 has now been burned down in Malibu, California. So in a way, I'm kind of glad maybe she didn't go there because all of Malibu is burned to the ground. But that was our whole problem since 1999, is I couldn't get her to go into a treatment center. We stayed engaged, and it's been an off and on thing for me to try to get her away from the things that she did. I can't mention names of her friends because I have children in Wichita and grandchildren, and I don't want anything to happen to them. The fact is, though, that what led me up to having to sell the house, that wasn't the plan. Melissa was supposed to be home in December 2020.
Mr. Camplan, I'm really not sure what this has to do with your decision.
I know, but that's what led me to the point of January 4th. I think the house was sold. The man that bought the house abandoned me on promises that I gave him such a good deal on the house. I ended up having to do the promises he made with money from Melissa's account because he quit midstream, and he fired one of the moving teams, and one of the moving units I was in, when I got help to try to make a hallway from people so I could get back and forth and see where everything was, in the very back on the left, and this is the truth, on the very back on the left, and this was last year in 2024, was a spot that was 12 feet by 6 feet wide, 12 foot long, 6 feet wide. Nothing was there. And then I found out a month and a half ago that the storage unit next to me, someone was living in there. And there was a crawl space that I saw when I saw that opening, but we filled it quickly and piled up as high as we could. But what was someone doing living in a storage unit with a crawl space into the next one with a 12 foot by 6 foot area? I'm still trying to find that out, but that's the kind of thing I've been dealing with. I've been having to pay people that I wasn't supposed to have to pay for things that were promised. And the thing that was promised to me is they would pack everything, because I can't, I'm disabled. They would move everything to a storage unit for me, which they started doing, but they drug it on and on. And instead of being out of the house in January, like I wanted to be, I didn't get out until June. And I lived in a car for 30 days, and I couldn't get to the bank money I had a deposit for a house in Chanute, Kansas.
Yeah, we still don't care.
They wanted cash, but I was going to go up and give them the money. But I couldn't because the bank account got closed for me to be able to do that. And I ended up having to buy something to live in. which is basically a trailer. It's parked in somebody's yard right now because he gave me permission. I don't even know the guy, but I asked him if I could because they put a tow notice on it, impound notice. And I'm running an extension cord from someone 3 houses down. It's a 250-foot cord to run a space heater and to charge my phones. That's what I've been doing since November. Was it a lake?
I'm not sure what
I
any of
know,
this
I
has
know.
to do
I
with the
understand.
decision that you need to make today.
Well, that's a lot of it for me because just dealing with everything I've had to deal with has been, it's not just, it hasn't been for me. This is all about Melissa. For instance, me being able not to see Melissa it hurts me, but it's more devastating to her. The fact that she probably in her mind thinks I abandoned her or something, you know?
Who's managing her affairs right now, Mr. Camplan? Do you know?
I don't know because
She does have a guardian and appointed that person.
They call me from the hospitals and the life care center, but I'm not allowed to call them or go there. So I don't know what's going on. But I did know at one time. I have witnesses and people that I've sent pictures to of Melissa's condition over the years. But I know that's not the thing. It's all about the money. And that's what I wanted to mention today. If we could find a way to follow the money, not only from me, but all the way back to a point where I have a letter from someone, which in 2021, that says, why would they be looking into Melissa's money in 2021? Or why is she not being able to walk without help? You know, it all, if you follow the money, Your Honor, this is more, it's in depth like I can't even understand sometimes because I trusted everybody to help Melissa.
All right, the state's case really involves money from December 22nd of 2023 forward.
I didn't.
I'm not sure what relevance 2021 would have, but.
Well, the money wasn't deposited in the bank account, I don't think, until January. Can't remember. But.
So really, I'm not going to get an answer today. Is that right, Mr. Camplan?
You want to know
if you want to accept the state's misdemeanor plea offer?
It's tempting, Your Honor. It sounds like something I would like to do to serve a probation and to pay a fine. But the problem is I don't know whether I can trust that or not. I mean, I could trust that I have to pay the money back. That's a done deal. But I can't sit here and honestly say that I trust that I won't be put in jail.
Well, if you're wanting me to make a guarantee, I won't.
Pardon?
That's an issue for sentencing, which I was going to defer.
Defer.
Put off, postpone.
He's doing a later date.
I need some additional information.
I've been told by people around me and I'm supposed to go see him, as a matter of fact, but I haven't had a chance. A prosecuting attorney in Wichita that might be able to help me with this. No, I know that sounds.
Well, the prosecuting attorney in Wichita won't represent you and probably won't even advise you.
No, they won't. But I'm being told that I need to take this to jury trial by a lot of people.
Really?
Yes.
Ultimately, that's your decision.
I understand, and I didn't. How do I explain this? When I transferred from Melissa from Olathe Medical Center to Life Care Center, I didn't pay attention to what I was signing. I really didn't. I was in such a
enjoy prison
shock of what had happened to her, that I had to find a place, and all the beds in Wichita are everywhere. I couldn't find an empty bed anywhere. The only place I could find an empty bed was Andover at the Life Care Center. But at the same time, when I started signing the papers, my concern was just to get her taken care of when I found out she couldn't walk anymore. So I just started signing papers, to try to take care of her. And that's...
Mr. Camplan, I have no doubt that your attorney's already gone over this with you, but I don't know that I have. So I will point out that you are being charged with a level 5 felony.
I understand that.
I have no doubt
good.
that Mr. Watts has gone over with you that the sentencing range is about from 2.5 years in prison to about 11 years in prison. You do understand that, right?
Oh, I do. Believe
Okay.
me, I do.
All right. Again, I trusted that you knew that, but I did want to make sure that you were aware that if you were to be convicted of the felony by any means, that's what you're facing.
Right. Your Honor.
Okay.
Your Honor, I expected this to happen. This is something I've been dealing with in Kansas since the year 2000, but it actually started in 2002. But I can't get into that. I can't. I know. I can't get into that. I understand that. I wish we had more time, Your Honor, because I have witnessed things and know about things in Kansas, especially Wichita, that some of it can be proved because they were caught, but some of it can't. And that's why I can't talk about it all and give names out, because like I was telling you earlier, I have too much happening in my life to endanger anybody else. And I know, but I'm saying that I tried to keep Melissa in the hospital in November 2019. One day I went to visit her to make sure she was okay. And somebody, one of her friends, had gone there and checked her out. I ended up taking care of Melissa myself from November to May. Showers, feeding, help walking her. I had no problems with it. I even got her to work on her curvature of the spine to where she was walking straight up and down. And then she had another stroke in May, and she kept repeating my name. And I couldn't figure out why she repeated my name.
Judge, he takes care of animals and he heals the sick. How can you be so mean?
And then I took her to the hospital. And it turns out she had what's called a traumatic brain injury stroke. And that's on paper. And it's why she kept repeating my name.
Well, I keep repeating your name too, but I don't get an answer.
I know. All right,
counsel, we need to get somewhere with this. The only thing I have before me at this time, Mr. Watts, is his declaration that he's not going to plead, that he still wants a jury trial. That's the one thing he said that I did understand. And I get the distinct impression that to be able to defend him properly, you're going to need some additional time to subpoena defense witnesses. Did I understand that correct?
That's correct, Your Honor. And
Right.
Mr. Camplan is going to have to name the witnesses that he believes support his theory of defense.
That's between you and him.
I understand
I
that.
did send one name. Your Honor. I'm sorry, Attorney Jay Watts.
I'm going to do a special setting for pretrial conference in this case, in person. This is an in-person proceeding. Mandy, I'm looking at the afternoon of Tuesday, April 1. Certain irony with that being the date. But I'm looking at the afternoon calendar, and I think we could work in this case for an in-person courtroom proceeding. Do you agree, Mandy?
Yes, at 2 or 3 p.m.
Okay. Mr. Watts, your calendar during either one of those time slots.
April 1 at, right now, Your Honor, I don't have anything set on April 1, so either of those would work.
Okay. I think I'm going to choose the 3 o'clock time slot for this case.
Your Honor, does that have a, are you just setting a status hearing, or are you setting a jury trial to go with that?
I'm setting a jury trial to go with it.
And the jury trial would be when?
That would be the following week on the Butler docket, which would be Tuesday, April 8.
Your Honor, just be getting back from out of town, so I'm really not available on the 8th. I could do the 1st for the pretrial, but I'm not available to start jury trial on the 8th.
All right. I want to check speedy trial scheduling then, Ms. Norris. The court's going to determine the continuance from this date to the eventual date set is going to be chargeable to the defense.
And Your Honor,
okay,
I believe that the last one was charged to the defendant as well, because he failed to appear.
yes. I would concur. So we have about 3 months from arraignment to that date in January. Then later, Mr. Camplan apparently appeared by phone on a kind of a surrender following a declaration of bond forfeiture bench warrant. Obviously, the continuance that was required by his non-appearance is chargeable to the defense. All right, I think we're in decent shape on speedy trial. Mr. Watts, would you and your client have an objection to setting this case for a pretrial status conference without actually having this live for jury trial on the April calendar?
No, Your Honor. I don't believe my client would have an objection to that.
All right, Mr. Camplan, I'm going to set another court date. We're going to look at this case again on April the 1st, but I'm not going to put the case on the trial calendar for the following week. If you still want a trial on April 1st, you're going to be on the May docket. Okay? So in fact, I think I'll just go ahead and do that. In an abundance of caution, I'll set the case on the May trial calendar. And let me come up with that date here. The case is moved to the trial calendar of Tuesday, May 20.
Yes, sir.
But I'm going to set this case for what I'll establish as pretrial conference for Tuesday, April 1st. I don't want that much time to pass before we review this case again. Ms. Norris, with that direction given, that we're going to set a pretrial status conference for 3 o'clock, Tuesday, April 1, in person, courtroom B, Butler County Judicial Center. Mr. Camplan, you're ordered to appear at the Judicial Center in El Dorado at that time. Same building where you are today, you'll just be in a different space. So make sure you get in there a little bit earlier before 3 so they can get you to the right location. Okay, Mr. Camplan?
Yes.
Your Honor,
I ask that the county attorney's office inquire with DCF as to the current status, as to how the alleged victim in this case's money and interest bank is being handled, if there is a guardian and or a conservator in place, and who it is. And if you can get that information and have that available for the court on April the 1st, you're certainly welcome to share it by email with Mr. Watts and I prior to that time. But if not, I would ask for that report Tuesday, April 1 at 3 o'clock. If you need a court order to obtain that information, this court's going to be inclined to sign it.
Yes, Your Honor.
And DCF may require that.
So I'm clear, Your Honor, that April 1 date is an in-person courtroom with all parties in the courtroom.
It is.
Yes, sir.
Yes. April 1, 3 o'clock. Again, Mr. Templin ordered to be there in person for further proceedings in the case. So in light of this, continuance chargeable to the defense, this case is removed from the trial calendar of next week. Again, it's deferred over for jury trial purposes, if necessary, to the May docket. In person, courtroom B, starting 9 o'clock a.m. Tuesday, May 20th, unless reset by future order. All right. Mr. Camplan, anything change from the time I talked to you last until now?
Yes, Your Honor. Melissa has been moved to 2 different hospitals since, with conditions that she wasn't suffering from in June. Just to let you know that I've been called by both Life Care Center and the 2 hospitals where she was at. And she is coherent and can answer yes and no. Just so I want someone to know that. And I think we all should know it. Melissa can answer yes and no and can make decisions, even on surgeries.
Well, I hope she's competent to manage her own affairs. I doubt if she's competently able to manage her financial affairs at this time.
Well, no, because the reason is.
No, okay. All right. We don't need to go any further.
I know.
Again, I'm going to ask the state to see who is indeed managing her state of personal affairs, in other words, her medical affairs, as well as her financial affairs at this time. Probably a guardian and conservator has been appointed, or it's in the process of being appointed. But I want that information before the court the next time we meet, if not before. So appreciate that, Mr. Camplan, but I think our business today is concluded. I think we've gone as far as we can. And we'll review the case again Tuesday, April 1, 3:00 p.m., courtroom B, Butler County Judicial Center.
And Your Honor, if I may, I apologize. I've got to be in front of the 2:30 here in a few moments. I did Mr. Camplan, but I can't right now. Mr. Camplan, if there are witnesses that you wish to be subpoenaed for that trial date now set for April 20, by that May 20 is the trial date, May 20. By the April 1 date that has been previously set, April 1 at 3:00, I need to know who you want to call as a witness, how to contact and reach them so I can issue a subpoena, and what it is you expect them to testify to. If I can't know those things, I can't call them as a witness and put them on the stand. Okay? And we talked earlier about hearsay. You can't testify to what other people told you. I have to have those persons present. Okay?
Correct.
I need to know who they are. Okay?
And yes. It's okay.
And I must have them by the April 1 date so I can get them subpoenaed. Okay?
All right. Understood. I'm working on that really hard.
Okay.
As a matter of fact, a thumb drive is being mailed to me and I haven't received it yet. And it's got a name on it I need.
Because once I have that list, we'll need to talk about who they are, what they might say, what the evidence would be, and other things which we don't want to talk about here. We're beyond what we can do here.
I understand.
Call me very soon with that information so we can get it ready for trial if that's what you wish to do. Okay?
I will.
Lastly, if there's a court security officer with Mr. Camplan, would you make sure he has a card that he can take with him, setting forth his in-person date, April 1 at 3:00? Okay, excellent. He's got
Looks like they've already done it, Your Honor.
Fantastic, and I appreciate their assistance. All right, if there's nothing further at this time on the Camplan matter, again, it's taken off the trial docket for next week. We've got future dates set. And at this time, this case is in recess and the meeting may be ended for all.
Well, that was just excruciating. Actually, it was interesting. But that was an interesting case. It was maddening. It's fine. But it was no Grandma's Gone Wild. You know? Grandma's Gone Wild takes the day. And that's saying something. Because we had the cook in jail who claims she was roofied. She was a whole trip. She was almost likable. But she's charged with some crazy stuff. Then we had the goof that that didn't want to deal with the judge because he has an attorney, except the attorney hasn't entered an appearance and wasn't there. So for the purposes of that hearing, you don't have an attorney. Except the one they're providing for you, but you're too stupid to take that. All good stuff. Fun stuff. Thanks again, Alyssa and Zach. Thank y'all for coming out. I appreciate it. I'll see y'all soon.